This is Brother Peter Dimond, and I'm going to be talking about the issue of jurisdiction. Certain people in the traditional movement hold the no jurisdiction position. This is the position that jurisdiction is only acquired from a lawful superior, and therefore, since all of the independent priests, and even the priests ordained after the election of the Vatican II antipopes, were not approved by lawful superiors, they do not have jurisdiction. Since jurisdiction is necessary for a priest to validly absolve in the confessional, a lack of jurisdiction on their part would mean that all of the confessions they hear are invalid. Many traditionalists remain unaware of the fact that in order for a priest to validly absolve in the confessional, he not only needs to be validly ordained in the traditional rite of ordination by a bishop who is consecrated in the traditional rite of episcopal consecration, but he must also possess what is called jurisdiction, or the authority from the church to hear the confession and forgive the sins of the penitent. In Session 14, Chapter 7, the Council of Trent declared, quote, "This absolution which the priest pronounces upon one over whom he has no ordinary or delegated jurisdiction has no value." End quote. So we can see why the issue of jurisdiction is quite important. The Code of Canon Law contains laws on how jurisdiction is obtained. Normally it is from a bishop with ordinary jurisdiction, who received his jurisdiction from a true pope. Since essentially all of the independent priests and other priests offering traditional sacraments today did not receive approval from a bishop who was approved by Pius XII, the last true pope, these people conclude that they do not and cannot have jurisdiction to hear confessions and do the other things that they do. In this talk, I will show why this position is completely wrong and refuted by Catholic history, by Catholic sense, by Catholic teaching, and even by the canon law commentaries which they wrongly think favor their position. We have addressed and refuted this completely false position in an article on our website, which can be found under Traditional Catholic Issues and Groups. However, there are many other facts and points that need to be covered to more thoroughly demolish this schismatic error. The biggest problem with the no jurisdiction position is that it fails to understand the distinction between ecclesiastical laws and divine laws. The laws of the Church which govern how jurisdiction is granted are ecclesiastical laws. That's why they've been changed many times. They fall into the same category as other laws which have been modified and revoked by popes. There were countless such ecclesiastical laws issued by past ecumenical councils. There were laws governing how monks were not allowed to hunt, how priests were to be accepted into certain dioceses, how no one was to found a new religious order, and on and on and on. Unlike dogmatic truths, ecclesiastical laws can be revoked, can be modified, and can cease to apply in a situation or in a necessity that was not envisioned by the lawgiver. In addition, the Church teaches that jurisdiction will be supplied, in various circumstances, to those who did not receive it in the normal fashion. These principles, including supplied jurisdiction, epikeia, and some others we will discuss, are mentioned in virtually every canon law commentary on these subjects. The application of supplied jurisdiction to this issue, namely, that the Church will automatically supply or grant jurisdiction to one who has not received it in the normal fashion, either because there is a situation of common error or a probable doubt of law or fact, is such an indisputable fact that this concept of supplied jurisdiction is specifically mentioned in the very Code of Canon Law itself. In Canon 209 of the 1917 Code of Canon Law, it states, quote, "In common error or in positive or probable doubt about either law or fact, the Church supplies jurisdiction for both the external and internal forum." End quote. Now, by merely citing this canon, we can already refute some of the advocates of the no jurisdiction position. For instance, one Barbara Lindenberg wrote a work against the idea that any of the independent priests could have supplied jurisdiction, a work which is fraught with serious doctrinal errors. She states on page 10, quote, "The apostles would be horrified today to see what has been added to the meaning of tradition, that is epikeia, common error and church-supplied jurisdictions, or whatever else might sound plausible to the unwary to sanction these deceptions." End quote. We can see that the very Code of Canon Law itself teaches supplied jurisdiction, a concept she calls horrible. Now, other advocates of the no jurisdiction position are a bit more theologically astute. They acknowledge the concept of supplied jurisdiction, but place grave restrictions on it. They often say that it's not granted to someone who has not been given jurisdiction in the first place. So that, for instance, the Church only supplies jurisdiction to someone who has already been a valid priest approved by a proper bishop, but whose jurisdiction has lapsed, or who is trying to use jurisdiction in a locality where he does not have it. And so they acknowledge supplied jurisdiction, but say that it is only granted to someone who has received approval and jurisdiction before. And this is, of course, completely false as well. This is refuted, first of all, when we consider the fact that the Church has always taught that all validly ordained priests in danger of death can absolve a well-meaning penitent. Even though they were never granted jurisdiction to hear confessions, they are given the jurisdiction automatically by the Church for the needs of the person who is approaching them in danger of death. In fact, this is also specifically mentioned in the 1917 Code of Canon Law. Canon 882 of the 1917 Code of Canon Law states, quote, "In danger of death, all priests and bishops, even those not approved for confessions, validly and licitly absolve all penitents whatsoever, of all sins and censures whatsoever, no matter how reserved or notorious." End quote. And this concept of supplying jurisdiction to priests who never had it before in danger of death did not simply come into existence with the 1917 Code of Canon Law, but was acknowledged throughout the history of the Church. Furthermore, in this very canon we see another example of the distinction between ecclesiastical laws and divine laws. There have been many canon laws surrounding the reservation of sins. For example, if a person would commit a certain act which would carry with it a specific excommunication, such as procuring an abortion, sometimes that would be reserved for a higher superior, so that only certain individuals could forgive those sins. But in danger of death or in certain necessities, those reservations do not apply. And so with these two preliminary facts and examples we've given, we can refute and knock down the first two pillars of the no jurisdiction position. Some of the advocates of the no jurisdiction position say that the Church cannot supply jurisdiction and does not supply jurisdiction to anyone who has not been approved in the normal fashion. That is, of course, completely wrong and refuted by the very Code of Canon Law itself. Others argue that the Church only supplies jurisdiction to those who have been previously approved by the Church and given jurisdiction. We can see that that is wrong as well. But that is not sufficient to refute their arguments, for many of them will admit that the Church will supply jurisdiction to people it has not approved previously, but that it does that only in danger of death. They contend that the Church does not supply jurisdiction to priests who were not previously approved to carry on a regular priestly apostolate and repeatedly hear confessions and perform the other actions that apply to the priesthood. So, is there any evidence that the Church will automatically supply jurisdiction to a priest who has not been properly approved by a true religious superior, and repeatedly give him jurisdiction to hear confessions and continue on in the other actions that are proper to the priesthood? The answer to that question is yes. We find a clear example of such a case in the Great Western Schism and with the Great St. Vincent Fair. As many people know, the Great Western Schism was a time of massive confusion. It lasted from 1378 to 1417. During the Great Western Schism, there were two and sometimes three different people claiming to be pope. There was only one true pope, of course, but at times two other anti-popes. Many different priests and bishops were ordained and consecrated by these anti-popes and by those who had been elevated by them. Near the beginning of the Great Western Schism, St. Vincent Ferrer was ordained in the year 1379. St. Vincent was from Spain, and shortly after the schism began, Spain took to the support of anti-pope Clement VII, the first of the Avignon anti-popes. St. Vincent was ordained by Cardinal Peter de Luna, who was one of the supporters of anti-pope Clement VII, who had been excommunicated by Pope Urban VI for supporting the Avignon anti-pope. So St. Vincent Ferrer was ordained by an excommunicated cardinal who was in support of anti-pope Clement VII, and that very cardinal, Peter de Luna, would go on to become anti-pope Benedict XIII, the second of the Avignon anti-popes. So St. Vincent was clearly ordained by a bishop and a cardinal who was not a lawful superior, but who in fact had been excommunicated by the true pope. St. Vincent was not guilty of sin because of the very confusing situation about which election was the canonical one, Urban VI or anti-pope Clement VII. But there is no doubt about the fact that Pope Urban VI was indeed the true pope, and that the cardinals supporting the anti-pope were not lawful superiors. Therefore, St. Vincent Ferrer was not ordained under a lawful ordinary in the Catholic Church, and he was not sent or given jurisdiction to hear confessions by a lawful ordinary in the Catholic Church. That is a fact. So, according to those who hold the no jurisdiction position, this is a clear case. St. Vincent Ferrer could not have had jurisdiction. All the confessions he heard, therefore, in his wide apostolate were invalid, according to them. According to their position, St. Vincent would have to be considered as one who is operating as a renegade, without true ecclesiastical approval, who had no jurisdiction and was not authorized to preach. Allow me to quote one of them to illustrate the point. Barbara Linneberg, aforementioned work, page 6, quote, "The local ordinary is the one and only source from whence jurisdiction for hearing confessions may be obtained." End quote. Therefore, he could not have had it, since he did not get it from the local ordinary. Same person, page 22, quote, "A bishop cannot consecrate with an excommunication hanging over his head. There is no law that permits this. Any priests ordained under them are also suspended, and their masses are sacrilegious and void of divine power." End quote. Therefore, St. Vincent Ferrer's masses were sacrilegious and void of divine power, because the bishop who ordained him, the cardinal, was excommunicated. Same work, page 33, quote, "How can these usurpers claim the Church will supply them jurisdiction, when this self-same Church never sent them in the first place? She, the Church, can't supply jurisdiction to priests that she never sent in the first place. And all priests must be validly as well as licitly ordained to even receive jurisdiction in the first place." End quote. Therefore, St. Vincent Ferrer could not have had jurisdiction at all. There's no way around the conclusion of their position. But their conclusion is completely wrong. We know this from the very fact that St. Vincent Ferrer is a canonized saint, and the Church would not canonize someone who operated a wide apostolate that was illicit, invalid, sacrilegious, and derogatory to the dignity of the Church and her laws. But secondly, we know that St. Vincent Ferrer did in fact have jurisdiction, even while he was under the Avignon anti-popes, because in the Bull of Canonization, published by Pope Pius II, he makes reference to St. Vincent Ferrer's vision, in which St. Vincent Ferrer is told and informed by the Lord that he is the angel of judgment. In the Bull of Canonization by Pope Pius II, which is cited in our article on jurisdiction, Pope Pius II said, quote, Like a vigorous athlete, he rushed to combat the errors of the Jews, the Saracens, and other infidels. He was the angel of the apocalypse, flying through the heavens to announce the day of the last judgment, to evangelize. End quote. So the Catholic Church has clearly endorsed St. Vincent Ferrer's apostolate while he was under the anti-pope, proving that he did not act invalidly, but rather validly, thus proving that the Church supplies jurisdiction to priests for repeated actions of confession and repeated actions and acts that are proper to the priestly apostolate, even if those priests had not been properly approved ever before. If those priests are acting in good faith and/or the people who are approaching them are in good faith for their reasons for approaching them, the Church will supply the jurisdiction. So this demolishes the argument of the no jurisdiction position. Number one, that the Church doesn't supply jurisdiction. And number two, that it doesn't supply jurisdiction to people who never had it before. And number three, that if it does apply jurisdiction to those who never had it before, it only does so in danger of death. Completely wrong and disproven by the case of St. Vincent Ferrer, which shows that the Church supplies jurisdiction to one who never had it before, was not properly approved, and it supplies it to him repeatedly for repeated acts. That's because the laws which regulate how jurisdiction is granted and how priests are approved are ecclesiastical laws. They are not dogmas. It's also interesting to note that the vision which Jesus Christ gave to St. Vincent Ferrer while he was still under the Avignon anti-popes called him to preach the gospel. Thus he was preaching without having been properly approved for preaching before, proving that the laws which require someone to be sent are ecclesiastical laws, and that the Church can send someone automatically. So, to us, this demolishes the whole no jurisdiction position and should be sufficient to refute their entire argument. However, some still try to get around it. One, Jerry Matitix, who has now embraced the no jurisdiction position, claims to have a response to this issue. He claims that there's a distinction between ordinary mission and extraordinary mission. And he says that St. Vincent Ferrer was able to have jurisdiction and was able to preach lawfully because Jesus Christ gave him an extraordinary mission and confirmed it by miracles. Thus, his argument is that someone who has not been properly approved cannot have jurisdiction unless he receives an extraordinary mission directly from Christ, which is confirmed by miracles, and that would be the only exception to receiving the proper approval from the lawful superior. Here's how Jerry explained it in a recent debate on jurisdiction. One of the participants gave me full permission to use the audio and comment upon it. After playing the clip, I will respond and refute his argument.
I also have on this handout that you're going to get some relevant quotes from the doctors of the Church, from St. Thomas Aquinas and from St. Francis of Sales, whom I've mentioned, from the Catholic controversy. His statement there, for example, that if someone is sent, he says, quote, "For if our Lord had sent these ministers, it would have been either immediately or immediately. We say mission is given immediately when they are sent by one who has the power from God of sending, according to the order which he has appointed in his Church." That was the mission of St. Denis into France by Pope Clement and of St. Timothy by St. Paul. Immediate mission, on the contrary, he says, is when God himself commands and gives a charge, without the interposition of the ordinary authority which he has placed in the prelates and the pastors of the Church. As St. Peter and the apostles were sent, receiving from our Lord's own mouth the commandment, "Go ye into the world and preach the gospel to every creature." And as Moses received his mission to Pharaoh, to the people of Israel, St. Francis of Sales says, I'm still quoting him, "No one should allege an extraordinary mission as opposed to the ordinary mission through the chain of command, unless he prove it by miracles," St. Francis of Sales says. "For I pray you, where would we be if this pretext of extraordinary mission was to be accepted without proof? Never was anyone extraordinarily sent unless he brought this letter of credit from the divine majesty." And that's right there in Catholic Controversy, page 13, page 19.
So we heard Jerry clearly explain his position. According to him, in order for a priest to have legitimate mission and/or jurisdiction, he must be approved by the proper superior, or he must confirm his extraordinary mission by miracles. And he cites St. Francis de Sales in the Catholic Controversy, who says that very thing. Well, first of all, St. Francis de Sales was speaking in the context of Protestants who were preaching a completely new gospel. He was illustrating to them the absurdity of their position, for not only were they preaching a completely new gospel and new teachings which are not consistent with the faith handed down in the church from the beginning, but they also don't have any approval from the existing hierarchy or authorities, and cannot confirm either their new teaching or their lack of approval by miracles. He was not talking about a priest who is trying to be Catholic but lacks a valid Catholic superior to have recourse to. It's completely different, and so the argument is not to the point at all. But secondly, Jerry's argument is completely refuted when we consider its implications. According to his argument, the only priests in the Great Western Schism who would have acted validly and/or legitimately would have been the priests approved by the valid line of popes and bishops, or the priests working miracles. So St. Vincent Ferrer might have had an extraordinary mission, according to Jerry, because he worked miracles and was sent directly by Christ. But what about all the other countless number of priests approved and ordained and elevated under the different anti-popes? Anti-Pope Clement VII had 36 cardinals. How many priests did they ordain? According to Jerry, they were all invalid and sacrilegious usurpers because they weren't working miracles. But that's not what the church taught. When the church resolved the Great Western Schism, it didn't even raise a problem with the lack of jurisdiction among the different lines. It actually simply said not to worry about that in the bull Ad Evitanda Scandala of Pope Martin V, which resolved the crisis. At the Council of Pisa, for example, in 1409, while the Great Western Schism was still well underway, this was the council which eventually elevated the third line of anti-popes. At this council, you had 24 cardinals, 4 patriarchs, 80 bishops, 89 abbots, 41 priors, the heads of 4 religious orders, and representatives of virtually every university. How many of those priests and bishops were elevated and ordained and approved by unlawful superiors? Almost all of them. Therefore, none of them had jurisdiction, and their preaching was unlawful and sacrilegious, and all the faithful during that time who approached these men to hear confessions were not having their confessions heard validly, according to Jerry's argument, because the only one we know of who was working miracles was St. Vincent Ferrer, or maybe a few others. That is absurd on its face, and completely refutes Jerry's argument, because if it were true, the church surely would have remedied that serious problem and told all the people who had made confessions to all of these different priests and bishops who had been elevated under these unlawful superiors and bishops and anti-popes to redo those confessions and the other acts which were performed under these unlawful superiors. But it didn't do that at all, simply because it understood that the church supplies the jurisdiction. It didn't hold this pharisaical, legalistic, completely false and schismatic position that Jerry and these other no jurisdiction advocates hold. To further show the absurdity of this position and the argument that Jerry advances, at the Council of Pisa there were over 100 doctors of canon law, 200 doctors of law, 10,000 visitors, all of them making invalid confessions, according to the argument. And in their dishonesty, these advocates of the no jurisdiction position might turn around and say, well, no, the church could have supplied it. Well, when they admit that the church could have supplied it to these men who were elevated by unlawful superiors, approved by unlawful bishops, and were not working miracles, okay, you are therefore disproving your entire argument and admitting that the priests who are functioning independently today, because they can't have recourse to a proper superior, and those laws aren't intended to bind in this situation, and these laws are all directed toward the salvation of souls, which is the supreme law of the church, the laws cannot impede the salvation of souls. And when they come to impede the salvation of souls, they cease to bind. That's the principle of canon law. Here's another quote to further illustrate the absurdity and falsity of their position. The Pisan anti-pope Alexander V, during this Great Western Schism, who was supported by over 100 doctors of canon law, and so obviously some of the faithful in good faith might have believed that he was the true pope, he published a bull called Regnans in Ecclesia on October 12, 1409. This bull gave the preaching friars, the Minorites, Carmelites, and Augustinians, full and uncontrolled power to hear confessions in every parish in Christendom. End quote. That's from The Age of the Great Western Schism, Clinton Locke, page 138. So this anti-pope is giving permission for his religious, not just the parish priests, but also the religious under him, who, according to the strict letter of canon law, were not validly approved, and they did not validly rise in the religious state because they were under an unlawful superior. He gave these men permission to hear confessions in every parish. According to the no jurisdiction position and Jerry's position, those confessions were invalid, but that's clearly absurd. And the Church never said that when it resolved the Great Western Schism, and in the bull Ad Evitanda Scandala, which was resolving this crisis, it said essentially not to worry about this, and not to worry about avoiding certain priests unless he has been named by a judge, and it didn't make even a peep of mention about the problem of jurisdiction. In fact, it's very interesting to consider that one of the cardinals who was instrumental in preparing for the Council of Pisa was Cardinal Odo Colonna. Cardinal Odo Colonna would go on to become Pope Martin V, the very pope who approved the Council of Constance and whose election resolved the Great Western Schism itself. So if anyone was familiar with the issues concerning different priests who were approved by different lines, and the fact that countless priests were preaching who had not been approved by bishops, who were under the true pope but rather under anti-popes, and were hearing confessions even though they had not been approved by bishops under the true pope but under anti-popes and thus unlawful superiors. It was Pope Martin V, and he did not mention anything about any problem of jurisdiction or remedying all of these supposedly invalid confessions and sins of illicit preaching, etc. That's because he understood Catholic teaching, and the consensus of the Church understood that the Church supplies jurisdiction and permission in those situations for those who acted in good faith, or for those who approached them in good faith. And so, frankly, to any Catholic who is thinking honestly and logically and using Catholic sense, this demolishes his argument that the Church only supplies jurisdiction or mission to those who work miracles. It's completely wrong. So we've seen that the case of the Great Western Schism completely refutes the advocates of the no jurisdiction position. So what do they do when presented with these facts? Well, most of them completely ignore it, but when they do address it, they sort of dishonestly shuffle it aside without actually addressing the issue at all. Here's an example of Jerry doing that very thing while making some other false arguments.
I mentioned some bad arguments near the end of my article. I give several of them, and several of them have already been shared today, so you can hear the arguments that Ken has made and hear what my responses to them would be. Pope Martin V's decree ad evitanda scandala at the end of the Great Western Schism is nothing to do with, doesn't help the CMRI out at all today, because a true pope at that point was supplying jurisdiction to those that were in good faith following a man that they believed was a true pope, like St. Vincent Ferrer. You can read all about that here.
This is a prime example of a bad argument and how one shuffles aside without really addressing a fact which he cannot refute. The true popes were not explicitly authorizing or giving jurisdiction to the priests operating under the anti-popes who opposed them. They did not do that. It was the Church automatically giving it to them, just like the Church automatically gives it to the independent priests who are operating or who might operate in good faith today, for the benefit of the faithful who might approach them in good faith today. To make the absurd statement that, well, that's different because there was a true pope reigning, that is ridiculous. In fact, if anything, the argument that the Church would supply jurisdiction today would be even stronger, because there is no true pope, whereas during the Great Western Schism these priests were operating under an anti-pope and actually choosing not to follow the lawfully elected pope and bishops. And so this is a subtly dishonest argument which might deceive those who aren't thinking more deeply about this issue or aren't as familiar with the issue, but it doesn't prove anything. And to say that ad evitanda scandala of Pope Martin V had nothing to do with this is misleading, because when he was resolving this confusion, he didn't mention any of these problems about the lack of jurisdiction for all of these years among all the priests who were operating under the anti-popes. And so there was no explicit authorization given by the popes to those priests under the anti-popes, contrary to what Jerry Matitix suggests. That's completely wrong, and it doesn't in any way refute the insuperable problem, which you cannot get around, that your position would require you to hold, that all the priests who operated under the anti-popes and all the people who approached them for confessions, countless confessions, were all invalid. And that's not what the church taught. Here are some other false arguments from Jerry.
The concept of moral theology of epikeia does not help out here at all. It's a much abused. This is the standard treatment, like Miaskovich on supply jurisdiction by Father Riley. And you can see, and again, I have it all written out here for you in bad argument number 7. Epikeia doesn't help in this debate. It only applies to situations to which the lawgiver has not addressed himself. Popes have addressed themselves to what you can and can't do when the papacy is vacant. It only applies in particular specific situations and not in general terms, as people have been now invoking it for decades. It can only be invoked by Catholics of good standing in the church. It only applies in the internal forum and not in the external forum. It does not objectively authorize external acts like ordaining priests and consecrating bishops. It can never confer jurisdiction. It applies to moral theology, not to canon law. Read the authorities themselves and see that.
There are a number of points that he brought up that need to be addressed. First, he tries to draw a sharp line between the issue of jurisdiction and epikeia. He essentially asserts that it's false to use epikeia as part of this debate. Epikeia is the principle of equity, the interpretation of a law whereby it is held not to bind in a particular case because some special hardship would result. So it absolutely has to do with law and whether one is bound to observe certain laws. To say that it has nothing to do with this issue, or to imply that, is very misleading. In fact, Father Maskevich, in a book he references repeatedly, Supply Jurisdiction According to Canon 209, he has a little section called Canon 209 in Epikeia on page 161. Likewise, Amleto Cicognani, a pre-Vatican II canonist, and professor at the Pontifical Institute of Canon Law in Rome, repeatedly mentions epikeia in his book, Canon Law. Obviously, it has a lot to do with this issue. Furthermore, if epikeia is inadmissible and misused, as he says, on what basis and on what grounds does he justify preaching? Jerry Matitix has an apostolate where he preaches all over the country and all over the world, in fact, giving talks, giving his view on Scripture, giving his view on the church's teaching in the day, advising people on where they should, where they shouldn't go. He absolutely preaches. Now, this is clearly forbidden by canon law, and so this is one of the examples of his profound hypocrisy. And a little later on we will see how he invokes the very principle that he called inadmissible in this debate. But before we return to that point, let's refute a little bit more of what he just said. Supposing for the sake of argument that what he says is true, that epikeia only applies to the internal, not the external forum, that it's not admissible in this debate, that it does not justify external acts such as ordinations, it doesn't supply jurisdiction, then his argument essentially translates into this: the church does not supply jurisdiction in the external forum. And that, of course, is completely wrong. For those who don't know, the internal forum is coram Deo, what is done in the presence of God. The external forum is coram ecclesia, what is done in the presence of the church. So essentially his argument is that the church does not supply jurisdiction in the external forum. For if that's not his argument, what's the point in saying that epikeia does not apply to the external forum? And that is completely wrong. The very Code of Canon Law in Canon 209 states, quote, "In common error or in positive or probable doubt about either law or fact, the Church supplies jurisdiction for both the external and internal forum." End quote. Now, there are some other things that he said that need to be refuted. He said that epikeia only applies to situations which the Pope has not addressed, and that this is a period where there is no Pope, and popes have addressed what you do in those situations. Well, that's a misleading argument because the popes did not address a situation where all of the bishops and all of the ordinaries that we know of fell into apostasy, so that there's not one legitimate ordinary to have recourse to. So that's misleading. Second, he says that epikeia only applies to those who are in good standing with the Church, and what he really means is that supplied jurisdiction can only be granted to those who are already in good standing with the Church. And we've already refuted that by citing the case of the Great Western Schism, where priests who were not in strictly good standing with the Church received supplied jurisdiction. I will also be citing Maskevich and his work, where he clearly gives examples and mentions that the Church does supply jurisdiction to those who were not in good standing with the Church, and that it also supplies jurisdiction in the external forum. In addition, the breathtaking hypocrisy of this man cannot be underestimated. He will justify preaching and publishing religious works, which is forbidden according to the strict letter of canon law, which he is trying to bind and apply. He will repeatedly justify the violation of that canon law. He will cast it aside and say that it doesn't apply to him, that he's justified, but that people aren't justified in administering sacraments or getting ordained for the propagation of the faith. That's not necessary. That's not called for, according to him. But that it's necessary for him to preach, for him to publish, for the propagation of the faith. The hypocrisy is stunning. He's condemned out of his own mouth. And at the same time, this heretic tramples upon the divine law because, as we cover in another audio, he justifies and acknowledges as Catholics people who deny the divine law, the dogma that you have to believe in Jesus Christ for salvation. So his devilish hypocrisy is really profound. Now, I want to address more of Jerry's arguments and refute them. In the following clip, I want people to pay attention to 2 points. First, notice how Jerry presents himself as a warm and loving friend. He speaks in soft and apparently charitable words. And this is very deceptive. And this is frequently how the devil kills souls. It's frankly equivalent to how a serpent will cuddle up next to someone and then try to bite him. He will lure them in with a warm personality, but if you analyze the content of what he's saying, it's actually deadly. Is he really their friends? What he's saying about these same people is that their priests are bastard priests, their confessions are invalid, that their churches are the equivalent of constructions of schismatics, equivalent to the schismatic national church or the Russian Orthodox Church. And so it's a frequent mechanism of the devil to present himself in a very friendly fashion, but then deliver a deadly message. And we've often been falsely accused of a lack of charity because we're blunt, we're upfront, we're honest. We will tell you how we feel. If you're not our friend, we're not going to act like you are our friend. And that's actually truly charitable, truly honest, and not phony. But this individual, throughout this talk, repeatedly praised their sincerity, how much he thinks of them, etc., except for the fact that he thinks that they're essentially schismatics, that they're renegades. He even compares their activity of ordaining people without proper authorization to the sin of incest committed by Lot's daughters. So just pay attention to that deceptive way of presenting the deadly message. And then also focus on his reference to Maskevich, because I will respond by analyzing what Maskevich actually says and how it obliterates their whole position.
Now, I want to reiterate, I want to encourage you please to read the handout carefully when you have a chance. And I want to reiterate what I said at the beginning of it, that I don't say any of the things that I'm saying now or said this afternoon with any ill will towards anybody here. I love everybody here. I want you to be pleasing to God. I want to be pleasing to God. I want to pray for you. I want you to pray for me. I want to consider you a friend and someone that we can work together and pray together and do God's will and God's work together. But I do believe with all of my heart that these issues have not been properly substantiated. The issue of mission has not been addressed. I would encourage you to read St. Francis de Sales. With all respect to Ken, although law does supply jurisdiction in very specifically circumscribed situations that the canon law itself tells us about. See, the whole purpose of canon law is to give you laws that bind. And then to say, but they don't bind in this situation or that situation. You can't say because some exceptions are made, therefore, it's a free-for-all. And we can start doing things that the canon law does not give us the authority to do, such as to say, look, we haven't had a pope for a long time, so let's start making bishops without papal mandate. Canon law talks about what you do when there's no pope. Popes have passed legislation saying, here's what needs to happen for the next pope to be elected. And they have never, I challenged Ken and he said, there isn't any. No pope in the 2,000-year history of the church has said, look, if a certain amount of time goes ticking off on your timer and no pope is around, then you better go ahead and start doing this. And in the absence of that license, that liberty, that authorization, we are sinning mortally in doing this. I say this with love. There is such a thing as supply jurisdiction, but it does not apply to this situation. Supply jurisdiction, there's a whole book on it, a classic treatment on it by Father Vyaskievich, Supply Jurisdiction according to Canon 209. Everyone cites it. You can read this whole book. I'd be happy to make you a copy if you can't find it. I think it's available on the internet, I was told. But you can read it for yourself, and you will see that everyone that reads this whole book and studies it says that this book devastates the traditionalist movement today that says we can make our own priests and we can make our own bishops.
Before I get into Maskevich's book, allow me to note that he repeats some of the same false arguments on mission, which was refuted by giving examples during the Great Western Schism, where priests who were not properly authorized or given missions were subsequently looked upon as having acted legitimately due to the confusion or the doubt of fact that would apply to a doubt of law or a common error scenario, as we will show. He mentions that popes did not authorize consecrating bishops when you did not have a pope, but as we said, this is not to the point because they did not address a situation where all of the bishops, all of the ordinaries that we know of, fell into apostasy. Furthermore, it's simply a fact of early church history that many consecrations of bishops were done without papal knowledge or prior approval, and that those consecrations were subsequently looked upon as legitimate. Anyone who studies the early church carefully knows that the popes were not involved in many of the consecrations simply due to either the distance, the lack of communication, or the political situations that arose. There were all kinds of bishops who were being implanted and then removed, and in many cases some who started out as not being properly consecrated with the legitimate approval of the Pope were looked upon as legitimate later on. There are many examples of that. He says that the Church only supplies jurisdiction in specifically circumscribed areas. Completely wrong. If that were true, as we said, if he were true to his argument, which he's not, if he were honest, which he's not, he would say that all the priests in the Great Western Schism who were not properly approved could not have had supplied jurisdiction, because it only applies in specifically circumscribed areas, not for repeated acts. And then there are many other examples in church history where you had priests who were maybe ordained by a bishop whose election was laboring under some defect, but they were of course considered to have jurisdiction. He says that anyone who studies Father Maskevich's book on supplied jurisdiction according to Canon 209 agrees that it devastates the traditionalist position that the Church will supply jurisdiction for these different acts, for ordaining priests, for hearing confessions, etc. That is completely wrong. I've read and studied the book, and I believe it devastates your position. And this is particularly significant because the principles he applies and the teachings he enunciates were written during his time, before Vatican II, around 1940, when there were bishops all over the place, priests all over the place. So even within a properly functioning hierarchical framework, he's still finding all kinds of examples where jurisdiction would have to be supplied by the church, where the church would supply it. What would he say if he were writing that for our situation where there are no proper bishops at all? And so what he says even applies, even has a greater magnitude in terms of the force of the argument if we consider what he was not thinking about when making these statements. And I'm going to cover what he was saying. Now, in Maskevich's work, he admits that in the early church they didn't even make the distinction of supplied jurisdiction. This wasn't even articulated in detail until the second millennium. Think about that. With all of the countless examples of bishops being invalidly installed, priests being ordained under bishops who were not properly installed. There are countless examples of this, and they didn't even articulate a distinction of jurisdiction because they understood that the church will supply it in any reasonable circumstance. Here's what Maskevich says on page 42, quote, "Abuses of usurpation of ecclesiastical authority existed in the church from the earliest centuries. The councils strove to eradicate these evils, but as regards the acts performed by these usurpers for people who were unaware of their incompetency, there was never raised any question about their jurisdictional validity." Wilches carefully adds that before Gratian there was no word of formal supplying of jurisdiction by the church. In fact, he points out there could not be any, inasmuch as the doctrine about jurisdiction was not yet fully developed. End quote. And so they didn't even get into these precise debates because they understood that if a person acted in good faith, or if there was a reason, or if there was a reasonability to presume that a person should have acted in this fashion, the church would supply the jurisdiction. Now we need to cover how Maskevich admits that the church will supply jurisdiction even to someone who does not have a title, to someone who has a colored title or a putative title. I will quickly explain what those mean and why that's significant. When a bishop, for instance, is legitimately installed as the Bishop of Philadelphia, he would have a title. That would be true title. A colored title would be one which has the appearance of a true title, insofar as it is conferred by a competent superior. However, it labors under a hidden defect which vitiates it. So, for instance, a true superior would nominate someone for a particular office or appoint him to that office, but there was a hidden defect in how he was approved. That would be a colored title. A putative title would be one where a person pretends to be endowed with power, but he in fact has no rightful claim to that position and was not conferred by a legitimate superior. So, for instance, when an emperor would install a bishop and say he is the Bishop of Alexandria and boot out the true bishop, that would be a putative title. And to better understand this, let's look at a real historical example of putative title. During the reign of Pope St. Leo the Great in the 5th century, in approximately 448 to 450, and actually in 449, a council was held at Ephesus called Ephesus II. It is a notorious robber council. This council was held by Monophysite heretics, but papal legates of Pope Leo the Great were there, and also the true Bishop of Constantinople, Patriarch Flavian. The Monophysites essentially hijacked the council, and it was an invalid and robber council, and they actually beat up Patriarch Flavian. The papal legates left, and Leo the Great rejected this heretical council. However, since the emperor was behind the Monophysites, he kicked out Patriarch Flavian, the true Catholic bishop and the rightful possessor of the See of Constantinople, and sent him into exile, and he put in his place Patriarch Anatolius. Pope St. Leo the Great obviously refused to recognize Anatolius' claim on the See of Constantinople. So, Anatolius was not the true Bishop of Constantinople. Flavian was, at least before he died. Now, Anatolius eventually changed his position and anathematized certain heretics and certain heresies, which enabled Pope Leo the Great to recognize him at that point as the true Bishop of Constantinople. So Anatolius started out as one having only putative title to the See of Constantinople. He was not conferred by a legitimate superior, but claimed to have that title unlawfully, unjustly. It wouldn't be colored title because it wasn't conferred by the legitimate superior, such as Pope St. Leo the Great. But obviously not all of the inhabitants of Constantinople were privy to all of these goings-on. So were all the confessions invalid, or at least those which were heard by the priests raised by Anatolius? It's not known, it wasn't even addressed. That's an example of where the church would supply jurisdiction for certain acts, even of one who has only putative title, essentially usurper, or one who has no rightful claim to the position. And Maszkiewicz admits in his work that the church will supply jurisdiction, obviously when one only has colored title and putative title and even no title. For example, on page 26 of his work, he says, quote, "Thus supplied jurisdiction may make valid the absolutions of a putative confessor," end quote, meaning one who is not the legitimate confessor at all. And he even spends some time commenting on the precise wording of Canon 209, which says that the church will supply jurisdiction in either common error or in probable doubt of law or in probable doubt of fact, and that the church will supply jurisdiction in any of those cases to both the external and internal forum. And he makes a note in his discussions of how if a specific title or any kind of title were required, that would have been mentioned in Canon 209, and that the fact that it was not mentioned means that it's not, strictly speaking, required for the church to supply jurisdiction. So he concludes that if one of those three things is present, and common error is often intertwined with probable doubt of fact or law, then the church will supply jurisdiction. And the reason for this is that all of these laws are intended for the salvation of souls. And when they come to impede that, because, for instance, a circumstance arises which was not envisioned by the lawgiver, they do not bind. That's what these Pharisaical no jurisdiction advocates do not understand. They are not dogmas. They are not divine laws. These are canon laws. And in commenting on the history of canon law and how it came to develop from the Roman law, Maszkiewicz says on page 39, quote, "They were becoming more and more convinced that the legislator did not intend any man-made laws to bind any longer, if, when, and as the observance of that law or its enforcement would defeat the very purpose of the institution, namely the public good." End quote. Now, I want to return to that point, but first I want to cover a few other things. Maszkiewicz says clearly and admits that the church will supply jurisdiction to someone who has not had it before. This refutes many of the no jurisdiction position advocates, if not all of them, because many of them say that the church cannot give it to someone who has not had it before, or who is not, quote, in good standing with the church. And Maszkiewicz says on page 25, quote, "Canon 209 is an instance in the code which reveals that the church does supply in conditions of common error or of a positive and probable doubt of fact or of law. In virtue of this supplying, the church may grant jurisdiction to one who until now has not possessed any." End quote. Okay, so that refutes a popular error that these no jurisdiction schismatics spread, and we already refuted that by giving examples in the Great Western Schism. Returning to the point about the purpose of canon law and these laws, as distinct from the divinely revealed truths that cannot admit of any exceptions or revocation. Maszkiewicz says on page 144, quote, "So too, in regard to her jurisdictional laws, the legislator has given innumerable signs of benignity and of grave concern for the good of the faithful. Above all, he has always been careful that his restrictions should never defeat, by their consistency and rigidity, their chief and ultimate purpose, the common good." End quote. And that brings us to another point which is crucial to understanding this issue properly. The advocates of the no jurisdiction position fail to make an important distinction. They will often cite church teachings and papal statements that the necessity to have jurisdiction is de fide. It's dogmatic. That's true. But they are failing to distinguish between the necessity to have jurisdiction, which is of divine law, and the way that jurisdiction is dispensed in the church, which is of ecclesiastical law. This distinction is of paramount importance in understanding this issue properly. The laws surrounding how a priest gets jurisdiction are ecclesiastical laws. The necessity for him to have it is divine law, and that's why we can see how the church can supply jurisdiction to someone who has never had it before. He needs to have it to forgive sins validly, but he doesn't need to get it from a bishop to have it in every case. That's the distinction they fail to mention. So all their papal statements about how the Pope has supreme jurisdiction in the church, etc., it's all beside the point. No one's denying that. It's simply a fact that the way that the jurisdiction is dispensed in the church is not strictly a matter of divine law or a dogmatic issue. Another interesting thing to mention is what Maskevich says concerning undeclared heretics and declared heretics. Some people say that the church could never supply jurisdiction to a heretic, declared or undeclared, and that the references to the excommunicated being able to perform certain acts with jurisdictional validity refers to people who are under excommunications that don't involve heresy, such as a minor excommunication, etc. Well, Maskevich contradicts that when he says, on page 19, quote, "The censured heretics and schismatics are not fit subjects of jurisdiction, inasmuch as their transgression has placed them outside the pale of active membership in the church. Such persons are always forbidden to exercise jurisdictional power, under the sanction that such an exercise will be an unlawful act. However, not always are their acts invalid. As Canons 2265.1, number 2, etc., explicitly state, it is only when such a person is a vitandus, or when a declaratory sentence has been executed against him, that his jurisdictional acts will be invalid." End quote. That shows that he also believes that the church will supply jurisdiction, for instance, for the validity of the confessions of an undeclared heretic, a priest who may profess to be Catholic, profess to be traditionalist, but in fact, sadly, is a heretic on one or more issues, but isn't as notorious as someone like Benedict XVI, or obviously a Protestant or an Eastern schismatic. Now, some also have confusion on this because they say, well, then couldn't a heretic maintain the jurisdiction of the papal office if heretics can have validity to some of their jurisdictional acts? And the answer is no, because the papal office comes with supreme jurisdiction, and no one outside the church could have universal jurisdiction. The church would supply jurisdiction to an undeclared heretic in certain circumstances for specific acts, such as absolving a penitent. But he could not possess universal jurisdiction or any jurisdiction which involves ruling, such as the position of head of the universal church. Now, it's necessary to cover a few more points from Maskevich. He admits that Canon 209 definitely applies to the external and internal forum. He admits that it applies to marriages and assistance at marriages, which is, he points out, not strictly speaking a jurisdictional act, but connected with it. And thus he speaks at length on how it is intertwined with this issue of the church supplying jurisdiction to the external forum. On page 221, he says that, quote, "Canon 209 has a much broader field of operation and application. As a matter of fact, it applies to all kinds of jurisdictional activity. It applies equally to the power to absolve from censures, to grant indulgences, to dispense from matrimonial impediments, to direct a judicial process, etc." End quote. So he's talking in the context here of when there would be a common error or a doubt of fact about who the proper bishop would be, that in his view the church could supply jurisdiction for those other acts, thus proving that it's not limited strictly to certain acts of the internal forum. And on page 228 he gives an example. He says, quote, "For example, a commonly but falsely reputed pastor validly absolves from sin, dispenses from the impediments of marriage, and dispenses from the law of assisting at Mass on Sundays and holy days, as well as from the law of fast and abstinence." End quote. Now he says for this to work, common error, or a positive and probable doubt about either law or fact, must exist. Now let's talk a little bit about doubt of law and doubt of fact. A doubt of fact is a situation where someone is reputed to be the pastor or the bishop who is in fact not. The case we discussed of Anatolius would be a doubt of fact among those who considered him to be the true bishop of Constantinople when in fact he was not. and that if there is a positive or probable doubt of fact, the church will supply jurisdiction. The case of the Great Western Schism would also be an example of doubt of fact, where people thought that this was their bishop, that this was the superior of the religious order, because they considered the Avignon line of anti-popes to be the true popes. The truth was to the contrary, and so there was a positive and probable doubt of fact. But the church will also supply jurisdiction in a positive or probable doubt of law, so that if a prudent man considers that this law does not bind or does not exist, the church will supply jurisdiction. And Miscavige makes the point that the church will supply jurisdiction equally in those cases, whether it's a situation of common error or a positive and probable doubt of law or of fact. And it's very interesting that Miscavige on page 101 makes reference to St. Alphonsus on this topic. And he points out that St. Alphonsus didn't really even distinguish between doubt of fact or doubt of law, that the church would simply supply the jurisdiction, essentially in any reasonable case. And I'm going to quote that. Miscavige, page 101, quote, "It is a remarkable fact that St. Alphonsus Liguori, in treating of the subject of probable jurisdiction, did not make any note of the distinction of the dubium iuris and dubium facti, meaning doubt of law and doubt of fact. This is particularly arresting when one remembers with what meticulous care St. Alphonsus habitually sought to portray controverted points in proper contrast and relief. Castrillion took it as an indication that St. Alphonsus himself held that the probability which arose from a factual doubt and the probability which sprang from a juridical doubt, meaning doubt of law, equally warranted the effecting of validity in jurisdictional acts." End quote. Miscavige also points out on page 97 that St. Alphonsus held the opinion that the sufficiency of common error alone without any title was, quote, "deservedly probable." So he didn't even have to look like the Bishop of Constantinople to have jurisdiction supplied to him, according to St. Alphonsus. Now, in unison with this, we must talk about what Miscavige says. He says that the church will supply jurisdiction in any probable case, and this is very interesting. Unlike in the sacraments, where there must be a certainty of validity, or there cannot be any objective doubt about the validity of the matter or the form, if there is, you must avoid the sacrament. In terms of jurisdictional validity, the burden of proof is on those who attack the act's validity. On page 192, Miscavige says, quote, "If there should be question of a jurisdictional act posited in the external forum, and the act's validity is questioned on the ground of defect of jurisdiction and of common error, the presumption stands for the validity of the act, and the burden of proof lies on the one attacking the act's validity." End quote. Now, in this context, it's very important to point out that Miscavige goes on and on about how the church in any questionable matters has to be considered, or most commentators considered the church would supply the jurisdiction, because if it wouldn't, then there would be massive confusion and uncertainty. And that's why he goes on and on explaining how this position developed of probable jurisdiction. And this point, in addition to all the others we've covered, frankly devastates the advocates of the no jurisdiction position. Miscavige says on page 89, quote, "In the meantime, between the 12th and 16th centuries, there had sprung up a universal custom on the part of confessors to absolve with only probable jurisdiction, that is, to act on the conviction that when they did so, the validity of the sacrament was still sufficiently safeguarded." End quote. So if it was reasonable that they could absolve, they would do it, and they were confident that the church would supply it, as long as it was probably reasonable. On page 92, Miscavige references Sanchez, a theologian, and he says, quote, "His point was that as long as the objective truth were not apparent, as long as the opinion asserting the presence or the sufficiency of jurisdiction were solid enough to win the assent of prudent men, the acts performed in virtue of it would be valid." End quote. So, as long as a prudent man considered that this is a justified act and that God would not necessarily want this act forbidden, the church would supply jurisdiction in such a probable case. And this coincides perfectly with what we instinctively thought all along, that the jurisdictional laws are there to provide a certain framework, a certain regulation, that people should operate within these bounds in normal times. But the church will supply it, because they're only human laws. They are backed up by the divine authority of the church, but they're not divine laws like dogmas. And so the only times where a confession would be invalid by virtue of a lack of jurisdiction on the part of the priest would be situations where the penitent was deliberately acting against church law in a normal circumstance, deliberately refusing to go to the one to whom he should go and going to someone else, or knowingly going to a notoriously heretical member of a sect such as a Greek Orthodox bishop to have his sins absolved. Any other cases which might arise where there could be any reasonable level of confusion, the church will supply jurisdiction, and that's why all these authors say that in any probable case it will, and it certainly will in this situation where every ordinary that we know of has fallen into apostasy. There are no ordinaries, and the church needs to have confessions heard for people to be forgiven of sins, and it is not reasonable at all to think that God would not want people having their sins forgiven. And what I've been saying is backed up by what Miscavige covers regarding the validity of marriages. He points out how certain marriages were considered invalid in the cases where the married individuals would deliberately shun the proper pastor or knowingly neglect to be married in front of the person they should have been married in front of, showing no regard for church law at all. But if there was any level of confusion about who could assist at the marriage's validity was upheld. And so the cases we're talking about in this situation are not comparable at all to people who deliberately act against church law in a normal circumstance. This is not a normal circumstance at all. Here's another quote from Miscavige, page 95. Tamburini also pointed out, and many others, after the manner of Bononcina, that probability was of itself, apart from common error, a sure guarantee of jurisdiction. Among these scholars, perhaps the boldest champion was Verricelli. He was so convinced of the truth of his own opinion that he termed the opposite view utterly false and improbable. Tamburini, who followed Verricelli, was an almost equally ardent adherent of this opinion. Tamburini gave as his reason why he considered this opinion the more probable the fact that universal custom gave jurisdiction. Thus this universal custom was the principal argument upon which these scholars rested their claim of certitude of jurisdiction in cases of probability." End quote. Here's another final interesting quote on this point on page 98 of Miscavige. Quote, "Certainly from the days of St. Alphonsus to the appearance of the Code, the legal factor of probability was ever more and more received as a guarantee for suppletory jurisdiction. But as Bucciaroni, Lemcul, D'Annibale have indicated, the most commonly used argument to support the claim that in probable jurisdiction there was inherent the guarantee of an assuredly real jurisdiction was the fact of its customarily and universally accredited usage." End quote. So if a prudent man considers the acts justified and not an infringement upon church law or the will of God or the Catholic faith, the church will supply jurisdiction in all those cases of probability. It's only when someone's deliberately acting outside the bounds of church law in an unjustified way that the acts will be invalid, or the people going to them, and even in that case it would be supplied for someone going to him. Now there are a few other points I want to make from Miscavige which shed light on this issue. On page 218, he again makes the point about what is probable. He says, quote, "The true test of this probability, one must insist, is whether or not such a doubt of fact can be defended in the external forum as warranting the assent of a prudent man." End quote. So again we see his reference to whether a prudent man would consider this reasonable in regard to assessing whether something is a legitimate doubt of fact or a legitimate doubt of law. He mentions in that quote a doubt of fact, but he applies the same criteria for assessing what is probable in reference to a doubt of law and common error. On page 104, Miscavige says something which is, again, very relevant to the purpose of law, and especially canon law. Quote, "As the centuries passed, there was a remarkable and steady growth and clarification of the jurist's conviction that the supreme legislator would not exact the strict fulfillment of the jurisdictional laws and requirements if, when, and as such rigid enforcements were to redound to the general harm of the subjects." End quote. So that's a key principle, that if the laws start to hurt the common good and the faithful, if they are to be strictly interpreted and rigidly enforced in a situation which the legislator did not envision, then they are not to be rigidly enforced and interpreted. Now, the next point I want to talk about is something that I marked in my notes called a flawed and weak science, and it refers to essentially how these theologians and even Meskevich cannot come to a conclusion on this issue. It's amazing when you read this work. It's 300 and some pages, and he goes through all kinds of theologians, citing all kinds of scholars on this side, that side, and he cannot give you a simple synthesized conclusion for all of this knowledge and all of this research about how and where the church will specifically supply jurisdiction. As we've covered, he enunciates and admits many principles which devastate the no jurisdiction position. However, in many questions about whether the church will supply jurisdiction here, he doesn't know, and all he can advance is a probable opinion. And I want to give some examples of that and explain why this is significant. Meskevich says that the church will supply when there is common error, but he's not sure when there would be common error. On pages 124 and 5, he discusses the issue. Quote, "In the first place, so they contend, who will determine what figure will satisfactorily fulfill the requisite number of those in error for it to be common error? Certainly the authors are not in agreement on this score. Even those who have made a real attempt at greater clarity and practicability by admitting that the error of many will suffice are not agreed about how and when many may be said to be in error. Consequently, because of such uncertainty and vagueness in regard to this essentially important condition, the interpretive school of canonists firmly contends that it is not permissible to agree that the Church has intended to subordinate the validity of her absolutions, etc., to a norm so inadequately clear, so vague, so practically impossible to determine with any degree of assurance. In the second place, granting for the sake of argument only that a definite figure or a percentage has been agreed upon, even then one will not always find it a simple task to ascertain the presence of the error of the necessary number of people. For certainly it would be necessary to distinguish those in error from those who are in mere ignorance, and then those who are truly in error from those whose error is crass and supine. It would be necessary to exclude the non-baptized of a certain locale, and it will be not clear as to whether the 20, 30, or 40% of the non-practicing Christians should be included or excluded. Such indeed are some of the difficulties arrayed against the wisdom of requiring the error to be real and common in the strict and traditional sense." End quote. So we can see that he doesn't offer any conclusion about specifically what is common error. He does the same thing about probable doubt of fact or law, except for the fact that he advances the opinion of many scholars who say that if it's probable, if a prudent man would determine that there is a doubt of fact or law, then the church will supply jurisdiction. But he is quite nebulous in assessing these questions and giving his strict opinion on this. And so, frankly, I have to say that this is an exercise in foolishness. For if you can write a 300-page book and consult all of these different scholars and array all of these different opinions and bring all of this different evidence and not synthesize all of your research all the time, all of the thought you've put into this, into a simple conclusion that people can work with, that the faithful can grasp, that can be utilized to help make decisions in practical life, then it's pointless. It's just one big intellectual endeavor which profits nothing. It's ever learning and never coming to the knowledge of the truth, 2 Timothy 3:7. And sadly, this Meskevich, who published his work around 1940, I don't know, but probably was a Salvation heretic, as most of the priests at the time were. And so it really struck me how this is really a pointless endeavor on his part, because he doesn't give us a conclusion for many of these critical questions. And this is the type of intellectual nonsense that a lot of these bad-willed people, especially in the traditional movement today, and even in the decades leading up before Vatican II, fell into. It was all about, the complexity of the arguments, the deep intellectual discussions, the scholarly research, but not coming to a simple conclusion. And that's where the devil deceives them, because the truth is simple and God is ultimately simple. And it's not smart, it's not intelligent to spend all of this time and assess all of these opinions and then not come to a conclusion. That's called stupid. And that is foolishness, that is bad will, that is not wisdom. And you can come to a conclusion. And I have to say frankly that we instinctively had a conclusion that was correct and actually borne out by the principles he enunciates in his work before even reading his work. And so frankly, a Catholic's instinct can tell him more with certainty than Miscavige does after all of his research. Namely, that if there is any reasonability to assume that there is a doubt of fact or a doubt of law, or that the church wouldn't bind you in this situation, and you're not acting directly against church law, the church will supply the jurisdiction. If he were of goodwill, he could have synthesized his research into that conclusion, but he doesn't. He lists principles and says things which prove that, but he remains in a fog and he's very murky about asserting his own position on precisely how to apply a lot of these questions. Here's another quote from pages 126 and 7, which illustrates the point I'm talking about. Quote, "The very purpose of law, to provide for the common good of the faithful. Such was the ultimate reason for Bucciaroni's defection from the traditionally accepted opinion on common error. He could not reconcile himself to the belief that the Church would say that a number of successive individual absolutions would be invalid, and that at a certain time after these instances of invalidity, the Church would begin to supply the deficient jurisdiction. Why the borderline case should profit at the expense of so many invalid absolutions seemed to jar Bucciaroni's concept of the benignity of the Church. It also seemed quite an anomaly to him that in the borderline case, that is, as soon as the error of many had actually been verified, the Church would consider the common good involved, but would not do so in any of the cases which preceded. This objection of Bucciaroni can easily be seen perpetuated in the works of innumerable authors who followed him in this view. Thus, for example, Wernz Vidal substantially reiterate Bucciaroni's thesis, insisting that the Church could not be said to supply for the common good if she did not supply until after many have already suffered from invalid confessions. They add that very often the sufficient number may be reached only at such a time when there is little if any use for the remedy." End quote. Here's another interesting quote from page 80, which further illustrates the point about how you can't really put a limit on it. Quote, "However, even if one could accurately determine that after such and such a time common error actually were present, would it not be true that the benignity of the Church would not benefit those persons who received absolution before the error had actually been committed by a sufficient number of people to become common? Furthermore, once the error had actually become common, undeniably the first person who thereafter received absolution would be validly absolved. But Bucciaroni could not see how the required conditions of common error and common good could be considered to coexist in the case of such a single individual. In view of such difficulties, Bucciaroni discarded the theory which required actual error. Instead, he taught that the requirements of the common error and of the public good were fulfilled from the very first absolution of the priest." End quote. And so Miscavige goes on about how do we know when exactly something is a common error so that then the Church will supply? Doesn't that seem unfair to the very last person who had his confession heard prior to the error actually becoming common? And the answer is this is all nonsense, that the Church will supply it for any of those who acted reasonably, as long as they didn't act clearly against church law and in a manner which was really without excuse and demonstrated grave neglect of church teaching and church law. And that's proven by their confusion, and at the same time they say, well, we can't really limit it, but And so I can see why someone like Jerry Matitix likes these kind of books, because it's just all about all of this scholarly information without coming to a conviction, without coming to a simple conclusion. And that was actually the cause of the Great Apostasy, because in the decades before Vatican II, these priests and so-called theologians started to think theology too much. They eschewed the simple conclusions. They tried to make things more complex than they are, and as a result, and in the process, their depraved minds explained away the dogmas, including the core dogma: outside the church there is no salvation. Meanwhile, they, in their blind pride, consider themselves so sophisticated, so deep, so learned, when they're actually fools who can't even come to a simple conclusion. I'll give one more quote on this point. There are many, but to further illustrate what I'm talking about, on page 193, Maskevich says, quote, "The limit of subjectivity is determined by the time-honored phrase that to merit the suppletory benefits of Canon 209, it must always be founded upon sufficient reason to gain the assent of a prudent man. As Lamy du Clerge and Crusson agree, that it is not always easy to draw, with mathematical precision, the line between the positive and probable opinion, and one that is not such." End quote. And so the conclusion of the reader who believes that they should follow what Maskevich is saying is, oh, well, we just don't know. But no, he has already given the principles which show that you can synthesize these valid principles into a conclusion. And so in conclusion on Maskevich, while he remains in a fog on how to apply the principles he enunciates, he devastates the no jurisdiction position and its advocates by admitting that the Church will supply jurisdiction to someone who has not had it before. He admits that the Church will supply jurisdiction to someone with colored title, putative title, or even no title in the Church. He admits that the Church will supply jurisdiction to an undeclared heretic. He says that the burden of proof is upon someone who is attacking the jurisdictional validity of an act in the external forum. He admits that the Church will supply jurisdiction in common error, in positive or probable doubt of either law or fact, and that these situations arise if a prudent man is persuaded that they have arisen. He admits that if a prudent man determines that there is a probability of jurisdiction because there is a legitimate doubt of fact or law, then the Church will supply jurisdiction in those cases of probability. And while the Great Western Schism was a case primarily of common error and doubt of fact, the situation we're dealing with today is a situation of common error and/or doubt of law. And another very important principle in this is one that is called the intrinsic cessation of law. In their commentary on the Code of Canon Law, pages 34 and 35, Buscarin and Ellis explain, quote, "A law may cease to bind in two ways, either by repeal, which is called extrinsic cessation, or by becoming inoperative without repeal, which is called intrinsic cessation. It is common doctrine that a law ceases to bind without repeal in two cases. First, if the circumstances are such that the law has become positively harmful or unreasonable. Second, if the purpose of the law has entirely ceased for the entire community." End quote. So this is an excellent example of how the laws would cease to bind in our situation by virtue of intrinsic cessation of the law. The circumstances are such that the law has become positively harmful for the salvation of souls. There is no valid ordinary to have recourse to. And even in the 1917 Code of Canon Law itself, Canon 15, we see an acknowledgement of this concept. Quote, "Laws, even invalidating or incapacitating ones, do not bind when there is a doubt of law. When there is a doubt of fact, the ordinary can dispense from them." End quote. So even in the case of an invalidating or incapacitating law, if there is a reasonable doubt of law, they do not bind. And to help illustrate this point, I want to give an actual example of this. And it relates to a controversy among some traditionalists regarding the message of Our Lady of La Salette. As many of our readers know, on September 19, 1846, Our Lady appeared in La Salette, France, and said Rome would lose the faith and become the seat of the Antichrist. It's quite an important prophecy considering what we're dealing with in the post-Vatican II apostasy. But many traditionalists bring up the fact that the Holy Office in 1915 and in subsequent years issued decrees which forbade Catholics from interpreting or publishing interpretations of the Message of La Salette. And so some people say that when we cite the Message of La Salette, or when others do it, that it's basically schismatic or mortally sinful or whatever. And this is another example of legalism gone awry and a false understanding of canon law. To make the point, I need to mention the fact that not many people know that way back in the 16th century, the Fifth Lateran Council had already published a decree, a disciplinary decree, about making statements that the Antichrist had arrived. And I wanted to quote this. This is a disciplinary decree from the Fifth Lateran Council, Session 11, December 19th, 1516. Quote, "They, meaning preachers, are in no way to presume or preach or declare a fixed time for future evils, the coming of Antichrist, or the precise day of judgment, for truth says it is not for us to know the times or the seasons." And certainly no one is saying that we know the day or the hour when the Lord will return, for he says that no man knows that. But the point here is that this was a disciplinary decree in the 16th century which wanted to curb people at that time and abuses where people were saying that the Antichrist was around. Okay, so it was a disciplinary decree intended for those times and circumstances. But obviously when the Antichrist arrives many centuries later, that disciplinary decree wouldn't necessarily bind. And so even if it hasn't been specifically revoked, it has passed out of usefulness. It's an example of an intrinsic cessation of a law. And the same thing would apply to the Holy Office decree in the year 1915, which forbade interpreting and publishing and commenting upon the Message of La Salette. They wanted to stop people or prevent people from saying that Rome was the seat of the Antichrist at that time. And you can understand how a true pope would want to do that. He wouldn't want people concluding or thinking that maybe Rome was the seat of the Antichrist while he was reigning. But many years later, when you're dealing with a man in Rome who is actually proclaiming himself the Christ, the Son of the living God, as John Paul II did in his first homily, preaching a completely new gospel, declaring that the gospel is man, overturning the whole Catholic faith, well then obviously you're in a completely different circumstance, where you're confronted front and center with Antichrist in Rome. Whether you think he is the definitive fulfillment of the Antichrist or not, you are definitely dealing with Antichrist in Rome. And so that decree of the Holy Office was a disciplinary decree intended for that time, and it doesn't bind when the obvious fulfillment of what Our Lady was talking about is right in our face. It's an example of intrinsic cessation of the law. And so the people who try to denounce those who are utilizing for the good the message and the startling prophecy that Our Lady made, which fits so perfectly with what is going on, are simply of bad will and misled. It's legalism gone awry. And what's ironic about this is that Jerry Matitix, who has become this legalistic Pharisee and schismatic advocate of this no jurisdiction nonsense, he quotes the Message of La Salette and uses it as if it's been fulfilled. He will point out that she said Rome will lose the faith and become the seat of the Antichrist. Well, if he wants to follow the strict laws, he shouldn't do that because the Holy Office forbade people from commenting upon it. So he violates the laws he wants to violate, and there will be more on that. And it's also interesting that in the very same decree it talked about how people are not to publish religious works. I want to quote that. In the very same Holy Office decree from 1915, it said, "Let people be subject to the sanctions given both by Pope Leo XIII through the Constitution of the offices and responsibilities against those who publish books dealing with religious things without legitimate permission of superiors." End quote. So, again, you have all of these no jurisdiction hypocrites who are completely refuted by the facts that I've covered, who publish books without permission, which is a violation, strictly speaking, of canon law. Well, they say, no, those laws have ceased, so they apply either epikeia or intrinsic cessation of the law, or whatever they want to call it, to the things they want to do, publish books, preach, etc., but all these other things, which are necessary for the salvation of souls, such as having priests to forgive sins, forget about it. That's not allowed. It's purely hypocritical. They're condemned out of their own mouths. And so God is not forbidding the faithful to acknowledge the fulfillment of Rome losing the faith and becoming the seat of the Antichrist. when it's obviously right in our face. That was a law not intended for this circumstance. Now I want to refute what the no jurisdiction position advocates say about consecrating bishops without a papal mandate. Their position is that it's never lawful to consecrate a bishop without a papal mandate. Here's how Jerry explains it.
You don't need a pope to come along and tell you otherwise when the popes of the past have already forbidden this. Pope Pius XII is quite explicit in legislation after legislation that anyone who consecrates a bishop without a papal mandate incurs automatic excommunication, is suspended from all priestly functions. And this is not talking about the minor excommunication that would still allow you to permit someone who is still a priest of the Catholic Church but undergoing minor excommunication.
Here's more on the same issue of consecrating bishops.
Ken has made the comment several times that laws do not bind when obedience to them is impossible. I agree. I agree with that principle. But it's irrelevant. It's true but irrelevant because it's not impossible to abide by this law. If canon law says that without a papal mandate you can't consecrate a bishop, then it's perfectly possible to obey that law. You say, well, then I will not consecrate a bishop until I have the mandate that not only canon law, but divine law requires. Because it is the teaching, the solemn, dogmatic teaching of the Catholic Church at the Vatican Council of 1870, for example, that all jurisdiction resides ultimately in the Pope. And the Pope delegates this authority to the bishops of the world. And therefore, the jurisdiction which these bishops want to claim extraordinarily is not being derived from the proper source. They are starting from, it's like building a house with a second floor, no first floor, no foundation to hold it up. It just can't float there in the air. In other words, it's irrelevant for Ken to say over and over again, look, we can't obey these laws. Of course you can. You just don't make bishops until you have the authority of a pope telling you to. Why did the church give you that? Please read the commentaries on these laws.
Jerry says that it's perfectly possible to obey the law forbidding a consecration of a bishop without a papal mandate. You just don't consecrate bishops. Okay, canon law also says that you can't preach without permission. Don't preach. It's perfectly possible for you to obey that law and not preach, and stop your preaching all over the country. It's also perfectly possible for you to obey the law forbidding anyone to publish religious works without proper approval. You just don't publish religious works, but you do that anyway, even though it's possible for you to obey it. It also says in canon law that when you convert someone, you must bring him to the local ordinary so that he can make his profession of faith and abjuration there. But since there aren't any local ordinaries, that would mean that you couldn't convert anyone because, according to the strict letter of canon law, you have to go to the ordinary. It's perfectly possible for you to obey that law. You just don't try to convert anyone, or you try to convert him and hope and pray that some ordinary comes along out of nowhere so that he can make his profession of faith to him. This is abominable hypocrisy. And before I get into refuting his false position on the consecration of bishops without papal mandate, I want to play another clip in which he invokes epikeia and admits that when he thinks it's justifiable, it's okay to violate the very laws he claims are binding.
On canon law. Can you please tell us who received you back into the church and by what means? And can you please show us the imprimatur for all your published works and website?
What Ken has just done is point out something that we both agree in this debate. That obviously there is a legitimate application of the concept of epikeia that can be invoked. And I have a whole section on it in the handout there. Because obviously Ken can't show any imprimatur for his writing or his engaging in the debate as well. Technically speaking, but if we follow the strict letter of the law, we cannot have a debate without the approval of the local ordinary, but we don't have a local ordinary to do so. In that case, however, canon law itself addresses that situation. It says that when the faith, and I have the quote here in the handout. Let me see here, I'll just read it right to you. Bad argument number 9. Jerry Maddox is such a hypocrite. What gives him, a mere layman, the right to give talks, especially talks or debates against the CMRI? And yet he has the audacity to argue that the clergy of the CMRI are not authorized to preach or otherwise function as clergy. Answer. Unlike the clergy of the CMRI, I do not violate the prescriptions of canon law in what I do. Canon 1325 explicitly says the faithful are bound to profess their faith publicly whenever silence, subterfuge, or their manner of acting would otherwise entail an implicit denial of their faith, a contempt of religion, an insult to God, or scandal of their neighbor. I concede to the clergy of the CMRI, the same right to profess their Catholic faith. What I deny is their right to function as clergy, duly authorized by Holy Mother Church, any more than I would have the right to do so if I were to say, look, we don't have a priest in Scranton, Pennsylvania, where I live. I'm going to go find an old Catholic bishop, and I'm going to get him to ordain me a priest and a bishop, too. Maybe I can get him to do what Archbishop Tuck did when he ordained Clemente Domingo bishop and priest and bishop in the same day, in contravention of all Catholic canon law and all Catholic history. Maybe I could do that because the salvation of my family requires it. No. We have a right to do certain things as lay people. We don't have the right to become clergy in ways that contradict the teaching of the Church.
If you listen carefully to this clip, you notice that there is a contradiction and dishonesty. He begins by saying, yes, we agree that there is a legitimate concept of epikeia, that he doesn't have an imprimatur, that he doesn't have approval for his published works. Therefore, he is violating the very canon laws which he wrongly claims are still in force and binding today. But then he tries to say that unlike these other groups, I don't violate canon law in what I do. So which one is it? Do you invoke epikeia or not? And so he wants to admit when he's confronted that yes, there is a legitimate concept of epikeia, but then try to give the impression that he is not violating canon law at all. It's purely dishonest. And so he draws a sharp line between what he does, preaching and publishing without permission, trying to convert people in a fashion that is not strictly in accord with canon law, since there is no ordinary, but says that no, you can't ordain a priest, you can't consecrate a bishop for the salvation of souls so that they can hear the confessions of people, give sacraments to people, etc. And that simply does not follow. And as we've covered, there are many examples in church history where people who were not properly approved for either consecration of bishops or their ordinations acted validly. So I just wanted to point that out to show the profound hypocrisy and how really that question alone, the fact that he doesn't have permission for what he does, blows his whole argument out of the water. And I also wanted to mention just a quick point about this Ken. This is an individual whom we actually debated on Baptism of Desire, that's on our website, and he admitted in the debate that he couldn't refute the arguments and changed his position, and so temporarily claimed to be in agreement with us. And he was also not really convinced on this jurisdiction position. He was sort of swinging back and forth or questioning it deeply, and he was reading our article, and I guess that helped persuade him, along with some other things. And so after really only being convinced of this jurisdiction position, the true position that these no jurisdiction advocates are completely wrong, for only a short time he decided to debate Jerry. And in the course of the debate, or actually before the debate, he was calling us up and asking for help and assistance, and we presumed he was in agreement with us on the issues. But in the course of the debate, he wound up promoting many different heretical groups and some of the worst heretics in the traditional movement. So it was really awful. He did make a few valid points, such as that Jerry doesn't have any permission for what he does, but he neglected to mention almost all the other points that I've covered today, which totally devastate the position, such as the ones on the Great Western Schism, and also the points from Maskevich's book. And then after the debate, when we charitably rebuked him for promoting heretical groups and priests in the debate, he seemed to acknowledge that it was wrong, and seemed to change his position again, but a few weeks after that, he completely switched his position again on salvation, and unfortunately became a promoter of the heretical groups which favor salvation outside the church. And so, unfortunately, he's a mass of heretical contradictions. Now I want to cover in some detail the issue of consecrating a bishop without a papal mandate. All of the advocates of the no jurisdiction position cite Pope Pius XII in his encyclical from June 29, 1958, Ad Apostolorum Principis, which was about the consecrations in China without a papal mandate. In that encyclical, Pope Pius XII sternly condemned consecrating bishops in China without a papal mandate, and he made it an automatic excommunication for anyone who would do it without his approval. And so the advocates of the no jurisdiction position cite this and say, see, this is clear. This is a clear law that if you do this without permission, this is an automatic excommunication. And I'm always stunned by their bad will and their failure to understand when they cite this. Because in the very same encyclical, and this is covered in our article on jurisdiction, which has been posted on our website for some years now, where we give the quotes from this very encyclical, Pius XII repeatedly mentions in this very encyclical that the issue of consecrating a bishop without a papal mandate is a disciplinary issue. It's not a dogma, contrary to what the schismatic Barbara Linneberg wrongly stated in her book. That means that it's a church law, just like it's a church law that in normal times you can't preach without approval, or you can't publish a religious work without approval. It's a church law. And they confuse the issue by saying that it's a dogma that the Pope has all jurisdiction in the church. That's true. But the issue of whether someone could ever consecrate a bishop without a papal mandate is not a dogma. Now I want to quickly give a few quotes from Pius XII's encyclical. From the aforementioned encyclical, paragraph 43, he speaks of those who try to justify their consecrations by, quote, recalling a usage which prevailed in ages past, end quote. So he admits that it wasn't always forbidden to consecrate a bishop without a papal mandate. And that's simply a fact. Anyone who studies early church history knows that many bishops were consecrated without the express approval of the Pope before he approved it, and often against his approval. That was going on all over the empire at different periods of church history. And the Pope didn't always immediately break off communion with those bishops. That's just a fact. And due to the inability to easily travel long distances and communicate with those who were very far away, the popes couldn't have been involved prior to all the consecrations of bishops. It just didn't happen. It's just a fact. And so it's a disciplinary issue. And on this point, I want to give another quote from Pope Pius IX in his encyclical, January 6th, 1873, Quartus Supra number 34, quote, the Apostolic See has at times tolerated elected patriarchs using their power before being confirmed by the See, meaning the Pope. It has done so because their districts were so distant, or because the journey was dangerous, or because of the reverses threatening more and more frequently from the predominance of schismatics of the same rite, end quote. So Pius IX simply acknowledges the fact that many bishops in church history were consecrated before the Pope even approved them. So consecrations without a papal mandate are a fact of history, and it's not a dogma, contrary to what some of these schismatics say, that you can't do it. Pius XII's legislation against what was going on in China was meant for that time. Yes, you should not do it against the direct will of the reigning and true Pope, obviously. He was not talking about a situation where there is no pope, where all the ordinaries have vanished into apostasy. And in fact, in arguing this point, he even says this. This is from paragraph 50 of the same encyclical. Quote, it is obvious that no thought is being taken of the spiritual good of the faithful if the Church's laws are being violated. And further, there is no question of vacant sees, as they wish to argue in defense, but of episcopal sees whose legitimate rulers have been driven out or now languish in prison, end quote. And so Pius XII even explicitly acknowledges and implies that if there were a question of vacant sees, they might have a stronger argument. But he says that there is no question of vacant sees. Rather, it was a situation where there are legitimate bishops, but you're trying to usurp their offices against my will. He's not talking about a situation where there are no bishops, and you need a bishop to ordain a priest, and there is no pope, and there are no ordinaries. So it's completely beside the point. It's a terrible argument. It's just amazing how more people who read this encyclical do not see it. And I just wanted to give one more quote from the encyclical to further demonstrate the point. In paragraph 43, which we've already cited part of, he speaks of how they, quote, indisputably prove that they follow this line deliberately in order to escape from the discipline which now prevails and which they ought to be obeying. End quote. So again, he says it in plain terms that it's a disciplinary issue which involves obedience to the Pope in the normal state of the Church's life. It's not in any way a proof that someone cannot consecrate a bishop without a papal mandate in a necessity such as the one we have now. So there are other points that could be raised on this matter, but I think that that is sufficient for someone of goodwill. Now I want to close out this audio series on jurisdiction by simply focusing in on the profound hypocrisy of the advocates of the no jurisdiction position. As we've mentioned, canon law teaches that one may not preach or publish religious works without the approval of the ordinary. In disseminating their false and schismatic view on jurisdiction, these people totally cast those laws aside and thus condemn themselves out of their own mouths. Here is Jerry Matitix admitting that to preach requires explicit jurisdictional authorization.
To preach, likewise, is something that requires explicit jurisdictional authorization. And I quote that as well here in this handout.
So he's obviously condemned out of his own mouth, but he actually tries to get around it by saying that he doesn't preach, he just talks and evangelizes. Well, that is patently ridiculous. And to further refute it, I want to examine what Pope Leo XIII said about this matter. In Pope Leo XIII's encyclical Sapientia Christianae of January 10, 1890, in numbers 15 and 16, he says that the office of preaching is reserved for pastors. But he goes on to say what part the laity can have in preaching and or teaching in a less than official capacity. He says, quote, "No one, however, must entertain the notion that private individuals are prevented from taking some active part in this duty of teaching, especially those on whom God has bestowed gifts of mind. These, so often as circumstances demand, may take upon themselves, not indeed the office of the pastor, but the task of communicating to others what they have themselves received, becoming, as it were, living echoes of their masters in the faith." End quote. And so, yes, the laity can evangelize, the laity can repeat what they've learned, but in normal times, under the strict letter of canon law, they cannot do what Jerry Matitix is doing. He is not, as Pope Leo XIII says, simply repeating what he has received. No, what he is saying has never been explicitly taught by any pope. No pope has ever said, you can't go here, you can't go here, you must believe this about this situation in this group. These are all his own personal conclusions. And so it's not equivalent to simply repeating what he's received and then directing them to the pastor, which is what the laity could do in a normal situation, and evangelizing his neighbor by directing him to the pastor. But no, rather he's coming up with his own views, publishing all kinds of works, holding a worldwide preaching apostolate. So the notion that he is just talking, not preaching, is completely dishonest and ridiculous. Furthermore, even if we granted his argument, which we don't, it's absurd, he publishes without approval, so he violates the canon law there. Canon 1385.1 and 2 forbids laymen to publish works on theology, scripture, canon law, etc., without approval from the ordinary. They completely ignore that, cast it aside. Not just Jerry, but most of these no jurisdiction advocates. And Jerry, as I mentioned already, shows his profound dishonesty because he wants to act like he's not violating any of the laws, but then, talking out of the other side of his mouth, says that, well, yes, I do invoke epikeia in a certain limited circumstance. And he further contradicts himself because at one point he said that epikeia does not supply jurisdiction, it does not apply to the external forum, while he invoked epikeia to justify his publishing without permission. We need to also mention that Canon 755.1 of the 1917 Code states that baptism is to be performed solemnly, that is, with all the proper ceremonies, except in danger of death. And Canon 757.1 states that the priest must use solemnly blessed baptismal water, Private baptisms by lay people are only allowed in danger of death, according to 759.1. So the point here is that according to the strict letter of canon law, you cannot even baptize your children unless it's done solemnly with all the proper ceremonies, since they are not approved priests and cannot supply all of the proper ceremonies and the blessed holy water. Their own position, adhering to the strict letter of canon law in this situation, would cause them to conclude that they cannot baptize anyone until danger of death. I mean, I don't know what else illustrates that their position is a position of the devil. Under the pretext of adherence to canon law, they would have people go through their entire lives unbaptized and thus outside the church and under the dominion of the devil, even though they wanted to convert. It's a position of schism. It's a position of pharisaical nonsense, which springs from pride and a misunderstanding and misapplication of church laws intended for a normal situation. Another law that needs to be mentioned in this context is Canon 23:14.2, which states that a juridical abjuration is done in the presence of the local ordinary or his delegate and at least 2 witnesses. Abjuration must be done in the form of the Roman ritual. And so abjuration is what was done when someone's converted from heresy. And so if they're going to try to convert people, and Jerry and these other people claim to try to convert people, according to the strict letter of canon law, they couldn't do it, because in order for him to make the proper abjuration and profession of faith, canon law says he must go to the ordinary or his delegate and do it there. But they say, no, that doesn't apply because this is a different situation. Exactly. You again condemn yourself out of your own mouth, and you show that your position is schismatic and of the devil. Now, some of these no jurisdiction position schismatics only make these arguments with reference to the 1917 code. Others, such as the schismatic Linneberg, she will cite past laws from other councils whose ecclesiastical laws intended for those time periods have long been revoked or fallen out of a binding nature. And that is even more absurd, because there are all kinds of laws from councils, such as how when people would get married, it would have to be announced in advance by the pastor in the church. Here's a quote from the Fourth Lateran Council under Pope Innocent III, Constitution 51, quote, "We decree that when marriages are to be contracted, they shall be publicly announced in the churches by priests. If any persons presume to enter into clandestine marriages, the offspring of the union shall be deemed illegitimate." And so it wasn't considered a legitimate marriage unless that announcement had been made. That means that, according to their position, no one can be legitimately married today, which is completely absurd. The truth is that these are laws which were promulgated for that period. They are disciplinary laws for that situation. And of course, there are the church laws that you have to receive Holy Communion once a year. As the Catechism of Trent points out, quote, "The Council of Lateran therefore decreed that all the faithful should receive the body of the Lord at least once a year at Easter, and that neglect of this duty should be chastised by exclusion from the society of the faithful." End quote. So according to the strict letter of that law, these people who don't receive communion once a year are outside the faithful. They're outside the church. But they say, no, that doesn't bind, that was revoked, it doesn't apply. Exactly. You just make the point again. And so their hypocrisy is stunning and abominable. And ironically, these very same people trample upon the divine law and allow violations of the divine law and God's dogmas, which are binding and do matter in this situation and in every situation. They accept heresies against the dogma. Outside the church there is no salvation. And they accept people as Catholic who reject that dogma, as proven by our discussion of Jerry's acceptance of such individuals as Catholics. And so they've fallen into a clear snare of the devil. As a result of their failure to really believe in God and stand for His truths, the devil has them binding things that aren't binding and ignoring the things that are binding. The problem with these different groups, such as the CMRI and these other independent groups who are offering traditional masses, is not that they want to spread the traditional mass. It's not that they want to say traditional masses. It's that they deny the dogma outside the church there is no salvation and accept natural family planning. Those are the primary problems. They're problems dealing with faith. And so the no jurisdiction Pharisees condemn these groups for what is not their problem, namely having priests ordained so that they can hear people's confessions, say masses in the traditional form, administer traditional sacraments, etc. They condemn them for that, but they ignore what is truly their problem, that they do not accept the absolute necessity of water baptism and the necessity of the Catholic faith for salvation, and the fact that they accept natural family planning. So they condemn them for what is not their problem, wanting to spread the traditional Mass, wanting to administer traditional sacraments, but for the most part neglect their violations of what really matters, the faith. And the faith is what people need for salvation. That's what they need to be saved, and that's why these jurisdictional Pharisees are so deceived. And what our Lord said to the Pharisees applies to them. Matthew 23:23, quote, "Woe to you, scribes and Pharisees, hypocrites, because you tithe mint and anise and cumin, and have left the weightier things of the law, judgment and mercy and faith. These things you ought to have done, and not to leave those undone." End quote. And they are exactly what our Lord spoke of in the Gospel when he condemned the Pharisees. For instance, in Matthew chapter 12, we read about how when Jesus went through the corn on the Sabbath and his disciples were hungry, and they began to pluck the ears and to eat, because they felt they needed the food. And the Pharisees, seeing them, said to them, "Behold, thy disciples do that which is not lawful to do on the Sabbath." But Jesus said to them, "Have you not read what David did when he was hungry, and they that were with him, how he entered into the house of God and did eat the loaves of proposition which it was not lawful for him to eat, nor for them that were with him, but for the priests only? Or have you not read in the law that on the Sabbath days the priests in the temple break the Sabbath and are without blame? But I tell you that here is a greater than the temple." End quote. And so Jesus condemned the Pharisees for binding things that do not bind in certain circumstances and in a necessity. And that's the principle of canon law, that necessity can make licit that which is normally illicit. And I think it's important to close with something that we read about in the book of 1 Maccabees. In 1 Maccabees, we read that some of the Jews made a mistake which is similar, though not quite as absurd, to what the advocates of the no jurisdiction position argue. In the Maccabees, the resisting Israelites were attacked on the Sabbath because the allies of evil King Antiochus didn't believe that they would fight back on the Sabbath. At first, the Jews, the resistors, did not fight back on the Sabbath because they believed it would be unlawful. Or, if you prefer to translate that into language for our times, they did not say Mass, they did not hear confessions, they did not consecrate bishops, they did not ordain priests, because they believed it was unlawful. But after their people were all being slain, the Maccabees changed their course and did fight back on the Sabbath. 1 Maccabees 2:32 and following, quote, "And forthwith they, the allies of King Antiochus, went out towards them and made war against them on the Sabbath. But they, the resisting Israelites, answered them not, neither did they cast a stone at them, nor stopped up the secret places, because it was the Sabbath, saying, Let us all die in our innocency. And heaven and earth shall be witnesses for us that you put us to death wrongfully. So they, the allies of the evil king Antiochus, gave them battle on the Sabbath. And they, the resisting Israelites, were slain, with their wives and their children and their cattle, to the number of 1,000 persons. And every man said to his neighbor, If we shall do as our brethren have done, and not fight against the heathens for our lives and our justifications, they will now quickly root us out of the earth. And they determined in that day, saying, Whosoever shall come up against us to fight on the Sabbath day, we will fight against him, and we will not all die as our brethren that were slain in the secret places." End quote.